Hello and welcome to WireWheel's weekly privacy roll-up. I'm Rick Buck. I'm Chief Privacy Officer at WireWheel, and this week I'm going to be discussing the recent Belgian APD decision on the IAB TCF, or the Transparency Consent Framework decision. So let's first start and talk about the TCF. I assume most people know what it is, but the IAP EU originally built the TCF in an effort to satisfy GDPR requirements for a legal basis for processing, storing, and accessing personal information or personal data on a user's device. The experience: when a user visits a publisher's website, it sees a pop-up banner. The user has the ability to accept or reject the consent to the collection and sharing of their personal information, for example, for retargeting purposes. The TC string generates a cookie. That cookie is placed on the user device, and it or it updates an existing cookie on the user's device to allow or prevent the use of their data. The TCF passes that consent preference to ad tech companies in the EU, and those companies rely on consent to collect and share and use personal data to deliver targeted and retargeted ads to people in Europe. Okay. On February 2nd, as many of us know, the Belgian DPA, the APD, fined IAB EU 250,000 euros, ruling that the TCF violated GDPR regulation. The decision came in response to complaints filed by a Dr. Johnny Ryan of the Irish Council for Civil Liberties and others, that the TCF breached various provisions of GDPR with respect to large-scale processing of personal data. Of significance, the ADP ruled that IAB EU is the controller of the consent information they collect rather than the processor. And as such, the IAB did not comply with applicable obligations to data controllers, including, among other things, one, they didn't appoint a DPO, and they didn't maintain a proper data processing register. Needless to say, IAB rejects the finding that it's a data controller and will likely appeal this decision. This decision is a big one. It's a direct hit to the ad tech industry, who, particularly in Europe, who relies on the TCF for consent compliance via cookie banners. It's made big waves through the industry. Certainly lots of talk going on about this. One of the leading voices that I listen to and that's been speaking about this is my friend Gary Keibel, partner at Davis & Gilbert. And I'll give you a couple of his quotes and his thoughts on this. And, from his position, and I fully agree, the IAB framework is the engine that drives the industry in the EU. This decision impacts the ability of the majority of the industry to engage in retargeting. And in ordering the deletion of previously processed data, the DPA is essentially saying the data is the fruit from the poisonous tree. So even if the moment of initial data collection, it did not comply with GDPR, then when that data is passed on onto others in the ecosystem, they're receiving tainted data. So for all intents and purposes, as of right now, any permissions that you've received via TCF are invalid. And so we'll need to think about how we move forward with that. Gary, thank you for those thoughts. Some findings. Okay, so one, what did the ADP rule? One, they found that IAB processes personal data as defined in GDPR. They found that IAB goes beyond merely designing a framework. They determined that the means of generating, storing, and sharing the TC string by which preferences, objections, and consent to the users are processed. And as such, the IAB had not demonstrated a valid legal basis permitting the processing of this personal data under TCF. Okay, so that's a big deal. Currently, the way that they look at it is consents are invalid because users aren't given specific, informed, and granular consent. So consent is not a legal basis, and resting on legitimate interest is invalid because the interests of the data subjects are outweighed by the interest of the TCF participants. Interesting interpretation. IAB, so what are they doing about it now? Well, they have a month to challenge the decision. They have 2 months to come up with an action plan to present it to the ADP to fix the issues. They have 6 months from the date of the approved plan to take action against the things that they need to fix. And some of the things that they're going to need to think about are coming to terms with a legal basis for the processing and sharing of user preferences. They're going to have to prevent consent being ticked automatically as a default in cookie banners. So you have to actually affirmatively consent. You can't have it pre-ticked. They're going to need to do audits of organizations that join the TCF. They need to maintain records of processing activities. They need to do DPIAs on their processing activities. They need to designate a DPO to ensure the compliance of the TCF. And that's just a short list of the things that the APD is going to be looking for as they think about maturing this program. So you're on the other end of this. You're an advertiser. You're a publisher. What should you be doing now? How are you interpreting all this? So first and foremost, I would say if you're relying on legitimate interest as your legal basis, you should change gears. You should require consent rather than legitimate interest. You should update your consumer-facing consent notices with specific, informed, and unambiguous consent, terms we've heard before with GDPR. You should add restrictions to your publishers that require that consent is the only legal basis, that legitimate interest is there as well. So both as you present it to your consumers and to your publishers. Another thing that was called out is that the consent management and the revocation of consent is confusing. And it's confusing because there are too many vendors associated with the consent strings that in a cookie banner, for example. And so the guiding advice is that you should limit the number of vendors added to your consent notices and limit them only to those that operate on your websites and your mobile apps. While this may sound contradictory, the list of vendors should be as comprehensive and as exhaustive as possible. So make sure that you include everybody that is on your ecosystem. And that list should include all vendors that process personal data from your users. They should also, your consent banners and your consent platform should offer a high level of control of how PI is, or personal data is collected and processed. You should also identify where international data transfers are happening. So think about adding clarity there. Note there has been no guidance on what's too many vendors, what's the right number of vendors, what's considered confusing or not, but there'll probably be more to come on that. Also in your notices, you should present the categories of data collected in your consent notices, right? And so you don't need to put all data collected, but just a general overview of the data categories, so that it's easy for users to understand what that means. The reasoning behind this is the absence of that makes it virtually impossible for users to make their informed decision about giving consent. An obvious one, make your consent withdrawal easy and accessible. So one example would be to make easily accessible links on your web pages and in your applications to your CMP page, so that people can easily get to and update their consent preferences. So a little bit of advice there. What's next? The ADP decision certainly can be appealed by the IAB, and they have some time to do that. I wouldn't be surprised if that's their approach. It includes a grace period for them to present a plan and then to act on that plan going forward. What's interesting here is that other DPOs across Europe certainly could weigh in on this decision and have similar impact on the ad tech industry. You should think about, as I just mentioned, updating your consents and the way in which you manage your targeting and retargeting programs. Certainly consult with your legal and your privacy team about how you're playing this game and things that you need to do in terms of changing the way you collect consent or reconsenting people that you've already got it from. This is going to be an interesting year. We'll see how this one plays out. The IAB's got in the crosshairs of the Belgians. Google Analytics is in the crosshairs of a few regulators, France in particular. So lots to pay attention to this year as it relates to those things. We'll continue to report on this and other related subjects, so stay tuned for more information. So that's it for this week. Thank you for tuning into WireWheel's weekly privacy roll-up. Join me again next week as we talk about the latest and greatest in the privacy world. Of course, if you have any questions about today's topic or privacy issues in general, you can email us at marketing@wirewheel.io. And again, be sure to keep an eye on WireWheel's LinkedIn page for future dates of our publications and our broadcasts. And we'll see you next week. Thanks so much for listening in. Bye now.